Well, good afternoon if you're on the East Coast, and aloha kakahiaka to our island friends way out west. You are listening to the Higher Education Regulatory Outlook for 2024, which is part of the Higher Education webinar series offered by the law firm Thompson Coburn. While folks are still jumping on, I thought I'd go ahead and get to some housekeeping, get that out of the way. If you have questions during the webcast, you can submit them through the Q&A widget. It's at the bottom of your screen, and we'll try to answer, I won't say as many as we can, but as many as time allows is probably the right way to say it, at the end of the presentation. A copy of today's slide deck is available in the resource widget. There are also 2 or 3 other things that we place there, and I will reference during the presentation, but really encourage you to take a look at that resource widget and download everything that's available. You can also find some answers to common technical questions located in the help widget at the bottom of your screen. So if you experience technical difficulties during the webinar, I'm the chair of the higher education practice. Those of you who are longtime listeners know that it's not just me. We have a number of other attorneys, and I look forward to getting other folks in during the year on several presentations that we're planning throughout the remaining months of 2024. But for the regulatory outlook each year, it has pretty much just been Aaron. So today you'll get Aaron Lacey all the way. My practice is pretty wide ranging, but a lot of it and sort of a real core focus is the topics of today's presentation. So here's our syllabus. First of all, we're going to start with an overview of the department's rulemaking activity. And then I'm going to take a step to the side for a minute and talk specifically about the 2 negotiated rulemakings that are sort of one recently completed, one that's underway. That's the student loan relief rulemaking and program integrity and institutional quality rulemaking. But candidly, I don't want to spend too much time on those. I know it's always interesting to hear about what's going on in DC and sort of the next big thing, but there are a number of important rules that became effective last July 1st and that are going to become effective this July 1st. So these negotiated rulemakings are interesting, but we really don't know what we're going to see yet out of those and when it's going to become effective, if at all. Where we know that the rules that went into place last year and are coming into place this July 1, those are things you need to be aware of and be ready to deal with. So really the bulk of the presentation, I'm going to try to focus on what's coming up quickly and is already in the law or about to be in the law. And so that's going to be talking briefly about, what bar defense to repayment looks like in 2024. I'm going to hit on the financial value transparency and gainful employment rule that takes effect July 1. There's another big rulemaking package that hit last fall that covered a lot of ground dealing with financial responsibility, administrative capability, and other topics. I'm going to hit some select items out of that rule, which could, warrant several presentations in and of itself. So this is really an exercise in trying to curate the things that I think are of most import. We'll talk about parent liability, the minimum maximum length rule, trademark pending, programmatic accreditation, state authorization and closure, professional licensure disclosures, financial responsibility, and finally try to hit on a little sub-regulatory activity. If you're saying to yourself, Aaron, that looks like a lot to try to cover in 90 minutes, you're right. I'm going to do my best to get through it at a reasonable pace. If for some reason we come up a little short, then you'll know that it's in the slides and you can always follow up after. But we're going to really try to get to everything. So let's just start with an overview of the department's current rulemaking. One of the things I like to do every year, and again, folks who listen in regularly know this, is to try to provide you with resources so that to the extent you want to follow up on things afterward, you have a lot of opportunity to do so. So first of all, the best place to look at what the department is planning throughout the year and sort of what's going on with its current rulemaking activity is the annual unified agenda of regulatory and deregulatory actions. Actually, there are 2 per year. The most recent right now is the one that was put out in fall 2023. By the way, if you pull the PDF in the resources widget of these slides, these are all active links. So if you click on that link or the picture, it will take you to the fall 2023 unified agenda for the U.S. Department of Education. And it spells out every single regulatory or deregulatory action that they've got in process at the moment, not just those that are going through NEGREG, but also those that are being carried out by other offices like Title IX through the Office of Civil Rights, as well as Office of Post-Secondary Education, et cetera. And it tells you the status of those. And if we're still waiting on them, it tells you when they hope to get proposed or final rules out the door. There are, I mentioned earlier, a couple of significant negotiated rulemakings that are in play right now. And there's also a website that the department maintains. And this is something that's really evolved over the last 5 to 10 years. It's pretty good now. I mean, not only does it show you all the negotiated rulemaking in play, but they post everything to this website. So any materials that was provided to negotiators, any materials the negotiators provided for consideration by other negotiators, the department attempts to put all of that there. So if you're interested in NEGREG, you want to follow this stuff more closely, I would definitely check out these 2 websites. Or you can just listen into the presentation. So let's talk about what was completed in the way of negotiated rulemaking in 2022 and became effective last July 1, which feels like a million years ago, right? I mean, there's just so much rulemaking activity at the moment. Things that took effect 6 months ago feel like they're passé. But it is really important to keep in mind that we had a whole significant set of regulations that went into place last July. There were 2 in 2022. And you see right here, what I've done is I've given you the Federal Register. So this is the date and the link to the Federal Register where the rule was published. And then underneath it, the bullets tell you the topic areas that were covered in that rule. So in fall of 2022, we had 2 different publications in the Federal Register. All of these rules became effective on July 1. And it covered a wide range. The headliner was probably the new bar defense to repayment regulations. But there were also significant changes to the change in ownership process and standards, among other things. And if you look, you can see the theme, particularly in this November 1 package that came out in 2022, it's discharges, right? And that if there's a single sort of central theme of this administration's higher education policy, I mean, at least arguably, it is loan discharge. And you can see here one of their first priorities and one of their earliest rulemakings was to get at pretty much all the rules that deal with different ways to discharge loans, whether that was the bar defense process, closed school loan discharges, total and permanent disability, false certification, et cetera. All of those things took effect on July 1st of 2023, so 6 months ago. And at this point, by the way, on each of these slides at the bottom, you'll see, one of the things we like to do is give you some sense as to how at this stage you could still potentially be involved. Now, once a rule's become effective, you can see the impact opportunities become pretty limited, which is the challenge, the rule through litigation. And one of these is being challenged through litigation, and we'll talk about that in a minute. But first, let's talk about what is slated to become effective this July in 2024. Actually, I want to correct this. That it says July 31st, 2024. That's incorrect. The effective date is July 1st, 2024. Apologies for that. So this coming July 1st of 2024, these different rule packages will take effect. These were all issued in fall of last year in 2023. Income-driven repayment plans, the new financial value transparency and gainful employment rule, and then you'll see very late last year, at least relative to the November 1st deadline, we saw another package of regulations dealing with financial responsibility, ability to benefit, certification procedures, which is fairly significant. There's a lot of stuff tucked in there, and standards of administrative capability. Again, at this point, the primary means by which you all could potentially impact this rule as a community would be to support litigation, because the rule's already been issued in final form. And once again, there is litigation concerning one of these rules in particular, which is the financial value transparency and gainful employment rule. So just to be really clear, the slide says July 31st, but these rules become effective July 1st of 2024. Okay. Moving right along, let's talk about the negotiated rulemaking that is presently underway. So the prior two slides, we were talking about final rules that have already been issued in the Federal Register, and those rules, some of them became effective July 1 of 2023 last year. Some of them will take effect July 1 of 2024, meaning this year, of course. But there's yet more negotiated rulemaking presently in process. There was 3 rounds of negotiated rulemaking that were completed in December 2023, and the topic there was student loan relief. Politico, Morning Education, or Higher, I think it's Morning Education still, just announced late last week that there are folks in Congress and on the Hill who are trying to get the department to schedule one more round of negotiated rulemaking on student loan relief. Traditionally, it's pretty unusual, not unprecedented, but pretty unusual that the department would add another week, and we'll see if that happens. Assuming they don't, then that neg reg is completed and would sort of next be moving into the proposed rule stage. There's another negotiated rulemaking that is in process. So there are typically 3 sessions that are scheduled. One of those sessions has completed. All 3 are scheduled to be completed in March, and it's more wide ranging, right? So the prior one, student loan relief, fairly focused, really talking about creating new mechanisms by which the department can discharge loans. Again, a real theme for this administration. Whereas this batch of negotiated rulemaking is managing issue areas that deal with, in some cases, issue areas that were covered by the prior administration, and a rulemaking that reached total consensus across all areas. So it's interesting they're revisiting this. I know some people have been a little critical of that. Accreditation, state authorization, distance ed, R2T4, cash management, and the federal TRIO programs. By the way, we are going to break all these down in a little more detail in a few minutes. I also wanted to just highlight, when the department announced its intent for negotiated rulemaking last year, and they said, we want to cover accreditation, state authorization, and these various topics. At the same time, they said, we also want to do a new rule or conduct a rulemaking on third-party service and related issues and improving use of deferments and forbearances. But those 2 topic areas were sort of dropped and are not part of the negotiated rulemaking that is currently underway. So, there is this notice from the department that it intends to get to these issues, but they are not presently being negotiated as part of the current neg reg underway. So that suggests that maybe they would try to mount another neg reg, or it could just be that they decide to punt. That having been said, if you look out to the right on each one of these issues, you'll see in parentheses, I have NPRM, colon, and a date. So if you go to the unified agenda, the department always indicates when they anticipate issuing the proposed rule on this topic. And what you can see is for student loan relief, the department is currently targeting May 2024. And of course, if they hold another round of neg reg, that could slow that up. For the neg reg that's underway presently on this larger batch of issues, the unified agenda is suggesting that they want to get these proposed rules out in October 2024. Now, one thing that's really significant that I'll highlight right away is if the proposed rule comes out in October of 2024, that means there is no way that it could possibly be issued in final form before November 1st of 2024, which means there's no way that you would have a final rule taking effect July 1st of 2025. So all of this is to say, this batch of negotiated rulemaking that's covering accreditation, state authorization, et cetera, it's almost certain that the earliest this could become effective, these rules would be July 1 of 2026, which means the administration is sort of not conceding, but just it's quite clear they're communicating, I should say, that this batch of rules is a second term batch of rules, right? Similarly, regulations on third-party servicer, improving use of deferments and forbearances. The unified agenda pegs a proposed rule on these topics for October of this year, which means the earliest these rules could likely take effect would be July 1, 2026, meaning in a second term. Still lots of opportunities to impact this rulemaking. In case you've never thought about these things and you're interested, coordinate with trade associations, participate in public meetings, nominate or serve as a negotiator. You can look up, it's publicly listed who the negotiators are. Sometimes we discover that we have clients and there's someone within their organization who is actually a negotiator and they may not be aware because it may be a very large institution, right? You can support those negotiators, you can review draft language. Sometimes there's an opportunity to schedule a listening session with the department on certain areas or topics. You can comment on the proposed rules, of course, and we believe that is a meaningful opportunity. It's unusual that the department is going to, dispense of a rule that you may not like entirely or just give up on it, but we have seen the needle move and nuanced positions change and considerations from the department that really it can be quite impactful. I'll just give you a quick example on this gainful employment, financial value transparency and gainful employment rule. In the proposed version, the department there was no sort of allowance for institutions, no sort of transitional concept. Everyone was going to have to report 7 to 8 award years of data in the first year that the rule became effective. And coming out of the proposed in the comment period, when the final rule was issued, the department included this transitional concept, and schools could elect instead to only report 2 award years. That's a huge difference, right? I mean, the proposed rule, 7 to 8 award years of data. The final rule, 2 award years of data. I mean, ask your IT and systems folks. I'm sure they're very grateful for that change. So comments matter. You can also schedule meetings with the OMB and ultimately challenge the rule through litigation. But quite a lot happening. Finally, just a couple other notes. I wanted to highlight that there are a few proposed rules coming that are not going through negotiated rulemaking. So the department is required, if they have substantive changes to the Title IV rules, so the rules that sort of carry out Title IV of the Higher Education Act, those have to go through negotiated rulemaking. But there are other laws that are under the purview of the U.S. Department of Education that aren't part of Title IV. An easy one is Title IX, for example. And here are some other examples as well. And these laws and the regulations, rather, that are carrying out these laws can be revised without going through the negotiated rulemaking process, but they could still be meaningful to you and your institution. So just please be aware. The department is also planning some new material on FERPA, documenting foreign source gifts and contracts. I know there's been a lot of question and concern around that for a lot of institutions. The department is planning on putting out some new rules that get at that notion. And so the proposed rule is expected in June of 2024 on that one. Some changes to the Carl D. Perkins Career and Technical Ed Act, or rather to the regulations by carrying out that act. Cybersecurity standards for institutions of higher education. The department's been sitting on that for a long time, but it looks like October may finally bring us a proposed rule, and then some changes to the department's debt collection practices. I anticipate primarily to expand their ability to collect debts, particularly around the use of administrative offset and some of those types of things. And, as with many of the other impact opportunities, there are opportunities here. There's no negotiated rulemaking, but there are still ways to provide input to the department, most notably to provide comments during the public comment period. And finally, though we're not going to talk about it at length today, as many of you, I'm sure, are aware, one of the big ticket items that we think this administration is still quite committed to getting out the door is their final Title IX rule. And specifically, we're talking about sort of their revision of the Trump era regulation governing how institutions of higher education are supposed to manage and respond to allegations of sexual misconduct on campus. Currently, this has been delayed several times. The Department for the Law has to review comments received during the comment period. It got over 200,000, well over 200,000. So that's a lot to review. And they've bumped a couple of times the release date for the final rule, but currently it is set for March 2024. So it could be in the next 60 to 90 days, your Title IX coordinators and others have a big new Title IX rule to try to digest. So I want to spend just a little time focusing a bit more on those two negotiated rulemakings that are underway before we jump into bar defense and gainful employment and all these other things that are already in the law and about to take effect or recently took effect. But focusing first on the neg regs, right? So the student loan relief rulemaking, some of these points I made, but I'll just quick hit to give you a sense of status quo. First of all, the department is really not revising existing regulations. With this rulemaking, they've introduced primarily a brand new section in the law, and the design is to sort of expand their ability to and to formalize and articulate their ability to permit loan relief to specific groups of borrowers. So again, very consistent with the theme here of loan discharge as sort of the primary policy objective of this Department of Higher Education. Negotiators met for 3 rounds, I mentioned, in October, November, December of last year. No further rounds are anticipated, though, as I also noted, as late as last Friday, there were folks in Congress who were pushing for another round because I think they want to, the folks who were pushing, I think, want a more aggressive proposal from the department that would create even more opportunity for the agency to discharge loans. Of the 16 negotiators, there were institutions had 4 seats. And what I mean by that is every time, usually you have 15 to 17 negotiators in a neg reg. This one started with 14 actually, and 2 were added during neg reg, which is something that can happen. And, you know, consumer advocacy groups will have seats, attorney generals and state agencies, et cetera. But there is some play there. And depending on the nature of the negotiated rulemaking, you may expand seats at the table for students and consumer advocates, or you might expand seats at the table for institutions. In this case, there were really 4 seats for institutions. So that would be, by way of example, you know, public institutions, proprietary institutions, HBCUs, like, you know, each one might have someone there. A proposed rule, again, has not yet been issued, but according to the Unified Agenda, they are targeting May 2024 for its publication. And once again, if this proposed rule hits in May 2024, we think this would allow the department time to get through public comment and get a final rule on the books, which would be potentially effective July 1, 2025. Let's see. A couple other notes. Just talking about what's in this thing, just to give you a little bit of a sense. I'm not obviously not covering everything that was just during neg reg, but what's interested. So historically, the U.S. Department of Education, when it went through negotiated rulemaking, which if you're not familiar with this process, really means they get 15, 16 folks together, each one representing a different interest group, and they provide draft language, and they sort of talk about, should we accept this draft language or not? Historically, if the department covered 5 or 6 or 7 different issue areas, the department would say, if we can reach consensus across all of these issue areas, then we, the department, will agree to use that language in the proposed rule. But the negotiators had to reach consensus on every single issue area. This administration has innovated, and you know, I'm sure this is up for debate, but I personally think this is a positive innovation. And what they have said is, look, if we've got 8 different issue areas in the negotiated rulemaking, we're not going to require that the group reach consensus on all of them in order to bind the department. Instead, if you reach consensus on issues 1 and 3, we, the department, agree that we'll be bound by, you know, the draft language that everyone agreed to on those 2 issues, notwithstanding the fact that we didn't reach consensus on the others. So that's why we've started tracking, and the folks who do what I do are now paying attention to which issue areas achieve consensus, because unlike in the old days where it was sort of thumbs up or thumbs down on everything, now if we reach consensus on specific issue areas, that means that the Department of Education will be using that draft language that we saw presumably in the very last round of negotiated rulemaking, and that achieved the thumbs up from everyone at the table. So what reached consensus here? There were a handful of issues. All the proposals, again, were really about, you know, circumstances pursuant which the department could waive loans. So the proposals reaching consensus included those that would permit the department to waive loans based on a borrower meeting a loan repayment plan requirements, even if they had not signed up for that plan, which seems to make sense. I think that's a good policy, right? Certain actions taken by the department against the school. So if the department, engaged in a termination action or denied recertification or something like that, and the student or the borrower was enrolled at the time that action took place, they might have a basis for a discharge. When a program or institution has closed and the department is doing a program review investigating or has determined that the program or institution has failed to meet, could be student outcome standards. The language actually includes, or engaged in misrepresentation or certain types of misconduct, or failed to deliver financial value. So there's a pretty broad range here. This bullet is interesting to me for a couple of reasons. I mean, one in particular is because they reference program. The department has a definition of when an institution closes. It's effectively when the institution ceases to offer instruction. And that's a pretty easy thing to wrap the brain around. It's a lot harder, I think, to understand what the department means by when a program has closed, how that is tracked. Does that mean if it comes off your eligibility and certification approval report? And if you're a private, nonprofit, or public institution, you don't list every single program on that report. So how would the department even know that one had come off? I don't know. There's a lot to unpack there. Again, this reached consensus, interestingly enough. So you'll definitely see something along these lines. But if you're a lawyer type and you're really trying to parse what this means, I think there's quite a bit that has to be sort of determined beyond the philosophical idea here as to how this would be implemented. If a borrower meets criteria for closed school loan discharge but has not applied, so there's an automatic closed school loan discharge that was in place, that the Obama administration put into place, that was then rescinded by the Trump administration. This administration has put it in there again, but it's held up in the Fifth Circuit litigation, which we'll talk about in a few. This would be another way of getting at that. It would allow the department, presumably, to execute on a closed school loan discharge without regard to whether a student has actually applied. And I assume it would work something like the automatic closed school loan discharge that's being hung up in the Fifth Circuit. And finally, if an institution lost Title IV eligibility because of a cohort default rate failure and the borrower was part of the affected cohort. So a lot of interesting stuff to digest. I mean, one big question is whether or not, this new expanded discharge authority is accompanied by an authority of the department to try to recoup the discharged amounts from the institution or maybe owners or affiliates or others that may have, for example, co-signed the program participation agreement. My impression during the discussions and negotiated rulemaking and the draft language is that the department isn't really focused on recovery, but rather is focused on its ability to unilaterally discharge loans, which I think is pretty consistent with what we've seen both at the political level and the rulemaking level from this administration to date. But that is certainly an important point that institutions of higher education will want to follow when this proposed rule comes out. Let's talk about the neg reg that's underway right now and covering that wider range of topics. This rulemaking, unlike the one we just talked about, is really focused on revising existing concepts in the law. So this sort of range of existing regulations I mentioned concerning cash management, state authorization, distance ed, and other topics. Negotiators have met for one round in a discussion. They met in January, as did the TRIO subcommittee. So this negotiated rulemaking features a subcommittee for TRIO topics. And historically, when I was a negotiated rulemaker, we had a subcommittee for financial responsibility. And usually the subcommittee is composed of folks who are expert in a particularly technical area. They'll meet a couple of times and then make recommendations back to the primary committee. And it is the primary committee that will actually vote on the draft language proposed by the department, taking into account any proposals or direction potentially offered up by the subcommittee. So in this case, we've had one meeting of the primary committee and we've had one meeting of the TRIO subcommittee. 2 additional rounds are scheduled for the primary committee in February, March, 1 more for the TRIO subcommittee. So it'll meet twice and then give its sort of report to the primary negotiators prior to their last meeting in March. In this case, institutions have more representation. They have 7 seats at the table out of 15. Now, keep in mind, consensus isn't achieved by majority vote. So having 7 or 8, consensus means everyone has to give it a thumbs up, right? So having 7 or 6 or 8 doesn't somehow tip the balance, right, out of 15. But it does mean that you've got more institutional voices in this case sitting at the table. And that makes sense because many of these issues like return to Title IV are very much topics that are meaningful and almost exclusively meaningful to institutions of higher education. I doubt many outside of higher education would have much thought about R2T4. A proposed rule has not yet been issued, but as mentioned earlier, the unified agenda suggests that the department is targeting October of 2024 for its publication, which means, once again, that this is a second term, if the Biden administration is reelected, a second term set of rules, right? Because the earliest that they really could become effective would be July 1, 2026. Just a few ideas that are getting thrown around right now. In the accreditation related issues, the department's really focused on, I think, depoliticizing a little bit, or depoliticizing, and then also trying to, in their view, improve the integrity of the accreditors. So, for example, they want to make sure that to the extent accrediting commissions have public members, that those folks don't have prior ties to institutions. They should really be bona fide public members. Another item that institutions should really pay attention to. So right now, accreditors, by the way, keep in mind, you may not know this, the Department of Education recognizes accreditors for the purpose of being Title IV gatekeepers, and those accreditors have to comply with regulations enforced by the department that govern the accreditors. So that's the rules that we're talking about here. And one of the things that the department requires is that accreditors act on institutions that are in a state of noncompliance within a certain period of time. And presently, there's some flexibility around that rule, which gives an accreditor ostensibly even more than a couple of years to allow an institution to exist in a state of noncompliance. The department wants to tighten that up, and they want to only permit institutions that, in other words, they're requiring that accreditors take action if an institution is out of compliance and it's the short of either the length of the longest program or 2 years. And 2 years may seem like a lot of time. The length of your longest program may seem like a lot of time. But, if you're having challenges meeting certain types of standards, particularly with regard to outcomes rates, for example, it can take a long time and one or two student cohorts to change, to move the needle. And so, theoretically, this is particularly a problem, I think, if you're a school that has shorter term programs. If you've got, if you're a career school or institution with career-based programs that are subject to outcomes rates, 2 years may really only give you 1 year from the date of the initial noncompliance notice. You have a year of students to try to improve your annual outcomes rates. And then by the time you get to your second annual outcomes rates, you are right on top of that 2 year mark. If you got a program that's shorter than 2 years, a certificate program or something along those lines, you may not even have that much time. So this is definitely one to pay attention to. The department, like all regulators, is concerned about the higher ed's contracting, right? And we've got an uptick in closures and mergers and teach outs and that type of activity. And they are constantly thinking about both how the department wants to manage these issues and also how the department wants accreditors to manage these issues. So it's not surprising they're revisiting those rules around accreditor substantive change and teach out plans. State authorization. The department is another hot topic for a lot of institutions. They want reciprocity agreements, requiring institutions to have a system to report student complaints to the state in which the student resides. It's probably not an issue for most schools. They're also talking about the governing board of any entity that oversees a state authorization reciprocity agreement, only including representation from state employees and members of the public. And you guys know there are one governing board in particular that has this role. And so, it's easy to see that this regulation, at least at the moment, is fairly targeted. Distance education. This is super interesting. The department is proposing to create a virtual location for institutions that would include all the students who are being instructed primarily through distance education. This is fascinating because right now, among other things, the department doesn't track really whether a student is primarily being educated through distance education, right? You've got hybrid programs, you've got 100% distance ed programs, but, sort of somehow tagging programs that are, for students who are being more than 50% instructed through distance ed. I'm not sure that's really a mechanism that we currently have available. But even more interesting is the idea of sort of creating a separate, I don't know if that's an additional location on your e-car or concept, and tying all your primarily distance ed students to that location. Of course, what happens if they're primarily distance ed one semester and not the next semester? And this is a really interesting concept. And one that I think institutions will want to follow closely. And then they're talking about if you're a clock hour program out there that's being offered right now through distance ed, or a portion of your clock hour program through distance ed. They're also talking about potentially limiting eligibility or even eliminating it for programs being offered through distance ed. So in other words, requiring clock hour programs to provide on-ground work or synchronous distance ed work, but asynchronous distance ed they seem to think is a problem. Just real quickly, R2T4, the department is revisiting some concepts there and trying to codify some existing guidance, particularly as it affects attendance-taking institutions and the determination of the data withdrawal. Cash management, the real focus here, among other things, seems to be on wanting to prohibit, this is the first bullet under cash management, prohibiting institutions from including the cost of books and supplies and tuition and fees. So there are a lot of institutions out there, and I suspect many on the phone today that, or the computer, that do this, that are presently including tuition fees and the cost of books and supplies. So this would be a bit of a shakeup if you had to restructure your things in a way to accommodate a new rule that prohibited that. And finally, the department I mentioned earlier, if you're involved in the TRIO programs or there's an organization in your community that is, the department is revisiting those rules. All right. So that ends our sort of what's going on right now phase. And next we're going to turn to, the new rules and the activity that is, I think, really meaningful here. And we've got about an hour to do that, which is great. Today's first secret word is quarterback. I assume that is because there are some important football games in the future, or one in particular. So please select the correct secret word from the choices shown below. And that would be quarterback, not to be confused with the others, right? So let's see. I see right now, I see my percentage. This is nice. I've got a new feature on our webinar platform that's showing me how many of you are submitting your first secret word. So I'm going to wait for just a second. This is fascinating to watch these percentages go up. But if you're an attorney and you're looking to get your CLE credit, please, please, please take just a moment and click that first radio button there. I guess it's not a radio button per se, but click that first item so we can make sure that you get that CLE credit. I'll give it just another 10 seconds or so because I want to keep moving, but hoping that all of you are having a chance to do that. And also, I'm sitting here in St. Louis, Missouri, so we've got a handful of Chiefs fans floating around, but I am on the other side of the state from those guys. But I get to see plenty of them in commercials because I feel like every other commercial involves Kansas City these days, at least for a sporting event. Okay, let's keep moving. So let's talk about borrower defense to repayment in 2024. I'm not going to go through this whole rule, but I just want to talk about sort of the outlook this year and what I hope institutions are thinking about right now. First of all, I wanted to highlight for folks, because I think this is extremely interesting. So the National Student Legal Defense Network, which really advocates on behalf of consumers, meaning borrowers, former students, put in a bunch of FOIA requests to the department trying to get data by school on borrower defense claims. And they got a lot of information back, and it's sitting on their website. And if you click this picture or where the word website is highlighted, it will take you to that data and you can download it. So according to that data, which is not perfect, it's sort of odd in the way that the department responded. There's some holes in it. What you can see if you look at the graphic on the right, what we got was total numbers from 2015 to 2021 through October. Then we got nothing through the first quarter of 2022. And then the department started producing spreadsheets in April of 2022, all the way through December. And each one of those spreadsheets shows you all the new borrower defense claims that were filed by institution. So it shows the total outstanding as of that date, as well as the new ones that were filed within typically that month. So what you could do is you could go through and determine how many you think, and we're going to talk about the sweet settlement in a minute and sort of the timeframes, but you could determine how many you think were filed against your institution and outstanding prior to June 2022, how many were filed between June and November, and then how many may have been filed subsequent November. And those are sort of the three dividing markers under the sweet settlement, which I'll show you in the next graphic. But before I do that, I just wanted to highlight some of the, takeaway from this data. First of all, the responses to these FOIA requests indicate that over 600,000 claims have been filed by December 31st, 2022, and that was a year ago. So, we expect that the number is more than that these days. It also, because it shows the by school data, it also shows that claims were opened that claims that were opened on or before December 31st, 2022, of 443,500 of those were still pending. Finally, and I thought this was just a fascinating data point, the claims pending as of, again, it was interesting, the department, the FOIA was through December 31, 2022, but the data actually is through January 20, 2023. And so it said of those claims that were pending, and we could see this because it shows every institution by institution, over 4,900 different institutions had claims pending against them. Well, there are about 5,900 institutions of higher education in Title IV. So what that means is about 83% of Title IV eligible institutions of higher education have bar defense claims pending, or did as of the very beginning of January 2023. And that number may be up now, but that's fairly remarkable, right? Fairly remarkable. Let's talk about what's going on with the rule. So the Biden administration created this new bar defense rule that took effect on July 1st, or was scheduled to take effect on July 1st, 2023. But in February of last year, the Career Colleges and Schools of Texas, CCST, filed a lawsuit down in Texas, arguing under a wide range of theories that the new rule violated the Higher Education Act, the Constitution, et cetera. They asked the court to enjoin the enforcement of the regulation, and the district court in Texas denied that request. But on appeal, a 3-judge Fifth Circuit panel granted a preliminary injunction with respect to certain aspects of the 2022 rule. So those aspects relating to the bar defense discharge framework and closed school loan discharge, there were some aspects that weren't included in the scope of the suit. As a result, as of today, the department continues to be prevented from enforcing its new bar defense regulation, meaning the one that the Biden administration negotiated and put into place. But I want to emphasize, and by the way, suit's still pending. That's kind of where we are right now. But it is very important to emphasize that there were 3 prior versions of the bar defense rule that were already, all of them sort of simultaneously sitting in the law and pseudo-functional, and those all still remain in place. So to be very clear, there is not a lack of a bar defense rule right now, or an absence of a bar defense rule. The bar defense rules that were in place prior to last July are still the law of the land. All that has happened is the new bar defense rule that was supposed to sort of take over and rewrite everything is currently held up in the Fifth Circuit, right? So, but the department still has the ability right now to be processing bar defense claims, and they are doing so under those rules and or under the direction of the settlement that they reached in another piece of litigation, the sweet settlement that came out of California. And you see, by the way, I should have mentioned earlier in the bottom right-hand corner of a lot of our slides, you'll see we provided the cites anytime we're citing to something. So for claims filed before June 22nd of 2022, the department is just discharging those loans. And the department has acknowledged, and they're doing so without adjudication. So if you had loans prior to June 22nd, 2022, and you didn't file a claim, you missed the boat, because the department is not even adjudicating those loans. They're just discharging everything. But they've acknowledged that without adjudication, there's no basis to recover against institutions. For claims filed between June 22nd of 2022 and November 15th of 2022, the department is adjudicating those claims under the 2016 bar defense framework. That was the Obama administration era framework. The department is supposed to adjudicate and render a decision, but if it does not, for claims during that period, by January 28, 2026, then those loans will be discharged nonetheless, and the borrowers will receive full automatic relief. It is our understanding and view that if claims from that period are adjudicated and relief is granted, meaning the loans are discharged, the department would have the ability to initiate a recoupment proceeding against an institution to try to recover. If they are not adjudicated and discharged because they time out, we think that it would be difficult for the department to take the position that then they could recover. This is, setting aside the practical consideration of whether the department has the resources to try to recover these amounts outstanding or would attempt to do so. Finally, for claims filed after November 15th, 2022, they're not covered by the sweet settlement, so they would just be adjudicated under whatever is the law of the land at the point at which they're adjudicated. I mentioned earlier, what was interesting about the FOIA request is that it was showing claims received by month. And the advantage of that is and it's through this period from June to December of 2022. So you can actually go through that data and determine how many claims we think preceded and would just be dismissed, and that's why I've never seen them. How many were filed between June and November of 2022? So we will see those, we expect, and have a chance to respond, and how many may have been received after that, at least through January of 2023. The department, and this is the last thing I want to hit on this topic, but it's important. So the department published an electronic announcement in November of last year, November 8th, 2023. And we published a blog post on this. Some of you may have seen it, many probably have not. And the department confirmed in that guidance, indeed, that it is presently focused on claims that were filed between June 23rd of 2022 and November 15th. So in that second bucket, right, I'll just go back to that slide. So we're talking about in this middle bucket. This is the grouping that the department is trying to get at right now. And they indicate that they hope to get all notifications out for all the claims that were filed during that window of time by April of this year, April of 2024. In the guidance, the department also observed that the vast majority of schools receiving notice had fewer than 100, which is what the spreadsheet suggests and has been our experience in working with schools. It also indicates that for a minority of schools that have, multiple applications, including in some cases over 500, that they'll be getting those notices later in the period. So as a data point, Thompson Coburn is working with a lot of schools right now on bar defense responses. And our experience has been that in fall of last year, moving into winter, most of the folks we were dealing with and working with were managing 10, 20, 30 claims. And now we are having folks call us and they're receiving 300, 400, 500. So we see the department doing what it indicated that it was going to do, which is sort of moving up the line and getting to the largest batches. Also, if you've been dealing with these, you may know, but I will confirm for you in case you didn't see the department's guidance, that the department acknowledged it's not conducting any substantive review of these applications. So if you've gotten some and you keep looking at them thinking, this makes no sense, it doesn't even look like the borrower has asserted a claim that would be the basis for a discharge. Like sometimes we'll see claims and it just says, I didn't like my teacher. That's not a basis for a bar defense discharge. The Department of Education is not vetting these at all. So if you're getting claims and they look like that, that's why. It's because the department's just passing them through, right? Give me 1 second here. I'm just going to take a toke on my tea. Okay. Unfortunately, the department also seems to suggest, and this is what I really wanted to get to, in their guidance, they seem to suggest that there is no adverse consequence for an institution that forgoes a response. Observing, among other things, that institutions are not required to respond, and that the department is not required to presume an institution is guilty based strictly on its decision not to respond. And both of those things are true, by the way. The law does not require institutions to respond. You have an opportunity to do so. Nor is the department required to presume, as a matter of law, that an institution committed the alleged misconduct based strictly on its decision not to respond. But the department is required to adjudicate the claim using a preponderance of the evidence standard. That means the department is going to look at all the evidence that it has on hand, and it's going to see if it believes it is more likely than not, 51%, that asserted misconduct occurred, right? In the absence of any statement or other evidence from an institution, all the department would have on hand would be the claim from the student alleging the misconduct, in which case, when it went to this balancing test, it would be, we think, all but certain that a preponderance of the evidence review would conclude with a finding in favor. So if an institution does not respond at all, I want to be very clear. Our view is there most certainly is an adverse consequence, notwithstanding the way some of the guidance was characterized from the department. We'll also offer you 4 other quick, easy reasons to respond. First of all, if someone alleges that your institution engaged in misconduct and you did not, or it did not, we think the institution should state that for the record. Also, please be aware there's nothing preventing the department from initiating a program review or other enforcement action based on the allegations of misconduct made in a bar defense proceeding. So, if you receive something and, you don't respond, even if the department ultimately didn't try to recover after the discharge, that allegation is still sitting there. And because you haven't responded, it represents an adjudication and conclusion by a federal agency that your institution engaged in misconduct, which could be the basis, if if there's a misrepresentation allegation or something like that, for another type of proceeding. Similarly, there is nothing preventing a plaintiff's attorney, attorneys general, or other third party outside the department from using FOIA requests to get their hands on BDR complaints and the outcomes, and to use those discharges as evidence of wrongdoing in a secondary proceeding under a state law, for example. Finally, we just want to reiterate, if claims filed after June 22nd are adjudicated a discharge, we do believe that the department would have the ability to seek recovery without regard to whether it does or not. If you want more on responding to bar defense claims, we did a webinar in September. It's on our YouTube page. There is a higher education list, which you can see out to the right there. These are all free. So please, 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 if you're looking for some pointers on how to do this, feel free to check out our YouTube webinar, our webinar that is on YouTube. Also, we have a BDR response guide, which is just 2 or 3 pages, and we offer some thoughts and protocols on how to respond to these complaints. And that is in your resources widget. So it's on our website, but it's also in the resources widget for today's presentation. All right, taking another toke on my tea. I don't know, is that a phrase that people use? My sense is it probably is not. Let's talk about the financial value, transparency, and gainful employment rule. So bar defense, the rule that recall the Biden administration's version was supposed to take effect last July. Financial value, transparency, and gainful employment rule is set to take effect this July 1st. On October 10th, the department published the final rule in the Federal Register. Again, you can click on that link or the picture to get it. There is significant data reporting required as early as July 31st, 2024. I'm going to say that again on the next slide, but I really want to hit this home because I think some people, folks think, well, you know, we've got these programs and the whole point of this rule is to sort of measure the programs and decide if we think the programs are good or not. We think our programs will be fine, so we don't have anything to worry about. And that may be true with regard to the metrics that are being used. But I also want you to be aware that as part of this rule, the department is establishing a significant new reporting obligation for institutions of higher education. And all of this data is due, even if you select the transitional option, which requires less data, it's still a lot of data that is due by July 31st, with a second tranche likely due by October 1st of this year. So if you have not paid attention to this rule or checked this out, please, someone at your institution should be looking at it now to determine how it may impact you and what steps you need to be taking. We also anticipate a lot of sub-regulatory guidance from the department, hopefully soon. The last time we had this rule back in 2015, under the Obama administration, there were so many electronic announcements and guides. The department had separate places on their website where they were hosting just the gainful employment electronic announcements because we were seeing them, you know, just on a almost daily or weekly clip. So please keep a lookout for that as well. When I say gainful employment, you know, some people also remember the legacy version of this rule and they think, well, this rule is really just for proprietary institutions, et cetera. I think that view is changing. I'm glad to say that I think a lot of higher education is becoming aware that this now applies to all of higher education. But if you are not aware of that point, hear me now. This rule impacts every program at every institution of higher education, at least every Title IV eligible program, right? When I say gainful employment program, if you're a proprietary institution, you probably already know that's every program you offer. If you're a private nonprofit or public institution, a gainful employment program is a Title IV non-degree program. So in other words, if you've got certificate programs that are eligible for Title IV, it could be a graduate certificate, it could be an undergraduate certificate, it's a non-degree program and it's eligible for Title IV, that's a gainful employment program. All of your other programs, so that's all your degree programs that are eligible for Title IV, are non-GE programs. Really important for the next 6 slides that we all be on the same page about this, right? So GE programs are your certificate, your Title IV eligible non-degree programming, right? Your certificates, diplomas, if they're Title IV eligible, that's a GE program. Your degree programs that are Title IV eligible are your non-GE programs. So this rule represents an extraordinary expansion over prior versions of this rule. The department, the metrics that the department is going to calculate along with a lot of other information are going to be made available to prospective and current students on a new department website. And it's going to label failing programs as low earning or high debt burden per the agency's determination. So just to be super duper clear, the department's going to start calculating new metrics for all Title IV programs, whether they are GE programs or non-GE programs. And it's going to build this website, and among other things, it's going to label them as low earning or high debt burden. It'll still be the case that only GE programs can potentially lose Title IV eligibility, but failing graduate level non-GE programs, I know that's a mouthful, but that means if you're a private, nonprofit, or public institution, we're talking about your graduate degree programs. So those are non-GE programs offered at the graduate level that are eligible for Title IV. If they fail, they will be subject to additional sanctions. They can't lose Title IV, but the additional sanctions certainly could have impact on enrollment, things of that nature. The new rule also, I said this a minute ago, please hear me, includes significant reporting and disclosure requirements for all institutions. So even if your programs are great and they have great performance under the metrics, you still have to get geared up to comply with the reporting, which takes effect as early as July 31st of this year, and the disclosure requirements. You have more runway on the disclosure requirements. The department indicates that most of those won't hit until 2026. But the reporting obligations are coming up fast. In case you're wondering, well, what is the likelihood of impact of this rule? So the department ran numbers. It's not a perfect simulation of what things are going to look like if this rule takes effect. There are some slight differences in the calculations. The data that was being used was older, but it's certainly indicative. And here's what the department came up with. So for non-GE programs, so I'm talking about degree programs offered by private, nonprofit, and public universities, the department projects over 842 public university programs, which currently enroll about 555,000 students, and 640 private nonprofit degree programs covering 260, 270,000 students would fail at least one of the metrics, either the new debt to earnings rate or the earnings premium test. And this is a quote out of the Federal Register. Rates of not passing at least one of the metrics are particularly high for professional programs in law, about 19% of law programs representing 29% of enrollment in law programs, theology, and health. That's a pretty incredible stat. So what we're talking about is about a third of the students who are currently enrolled in law programs at private, nonprofit, and public institutions are enrolled in programs that, under the department's projections, would fail one of these two tests. The department also projects about 390 graduate level non-GE programs, which incorporate some of those law programs, would fail and be subject to the heightened standards. That covers, like I said, about 122,000 students. And here's a just fascinating point at the end. 82.7 of non-GE programs were actually excluded from this data because of various reasons, but primarily because the department didn't have enough data for some of those programs, right, across the applicable cohort periods. But what that means is while the percentages might hold, the actual numbers are probably understated, right, when they talk about number of students impacted, right? GE programs similarly impacted in a meaningful way, right? So, we would expect for public and private nonprofits, this would be a much smaller number because you guys don't offer very many GE programs. For proprietary schools, all your programs are GE programs, so we expect much bigger numbers. And truly, the department projects about 1,440 proprietary GE programs would fail at least one of the two rates, right? Of those 1,440 failing programs, the department anticipates that about 65% are undergraduate certificate programs that only fail its new earnings premium test. So it's really the new earnings premium test that is the primary impactor here. And the highest rate of failure is in personal and culinary services. So we're talking about massage therapy, culinary programs, and cosmetology programs. And for those guys and for you all on the line who operate those types of institutions, this is certainly a rule that warrants the highest level of attention. And for that reason, not surprisingly, it is the American Association of Cosmetology Schools that filed a suit and has already filed a lawsuit challenging this new rule. It is an existential threat for that industry, I think. That is a fair statement. And they were the ones who filed the lawsuit against the prior version of this rule, by the way. That is one of the potential avenues by which this rule could be enjoined and eventually, impacted. And then, of course, we think the 2024 presidential election will impact this rule's viability. I think it's a common misconception that the Trump administration rescinded all of the Obama administration's rules. That's really not true in most cases. And financial responsibility reporting is a great example, or bar defense, right? The Trump administration didn't strip those frameworks off the books. They augmented them, but they didn't get rid of them entirely. Gainful employment is one of the few places where that really did happen, where the Trump administration just said, look, this whole thing we can't make sense of. They went through a neg reg and they kicked it out. And so that's to say, like, the very existence of this rule is really politicized. And our expectation is, a Republican administration, if they came into the White House, would probably take steps to pull it off the books once again. The department may struggle as well to timely implement the rule. It's extraordinary. I mean, I'm not going to go into it in this presentation, but I will point out, well, let me go ahead and say this. I talked about the data reporting, right, and how significant it is. I mean, you're talking about the department wanting you to report a significant amount of data for every student in every single program at every single institution of higher education, right? So we're talking about 6,000 schools, hundreds of thousands of programs, millions and millions of students. It can't all be done automatically. I mean, there are going to have to be human-based decisions that are made. And it just really begs the question whether the department has the hands on deck right now to implement this rule. I don't think that's been this administration's priority through the first term here. I think their priority has been to get these rules through and then figure out how to implement them. But I mean, I do have a real question in my mind. If the department can't get, any increases in funding, and the department doesn't have fee authority, so it can't charge fees to schools, where's it going to get the funding to get the resources, human and otherwise, to turn the crank on these rules, which is sort of, in my mind, mean propelling them forward. Important for schools to initiate conversations among institutional leadership, to be aware of this rule and talk about how it's going to be managed. And it touches lots of different divisions within the institution. First and foremost, you need to determine whether you're going to do standard or transitional reporting and begin developing a reporting plan. Because if the rule's not enjoined, you got a lot of data that you have to report by July 31st of this year. Also, we think it's wise to model program performance if you can, because the window of opportunity to improve programs before they become ineligible is actually much shorter than many people realize. And finally, we really think some sort of debt to earning consideration is here to stay, whether it's this rule or another rule, whether it's at the state level or the federal level. And as uncomfortable it may be for higher education, we really think this is the direction the world is moving. And with that in mind, would suggest that institutions seriously consider integrating some sort of debt to earnings analysis into their program development processes, right? Okay, here's the implementation timeline. I'll just highlight the biggest dates, which are, again, July 31 is the deadline to report the initial round of data, with some additional data likely due October 1st. December 31 is another deadline for certifying GE programs. We think that the first round of metrics, should this move forward, will be crunched and issued in the first half of 2025. You'll have more data to report in October 2025, and then July 1, 2026 is when all these disclosure, acknowledgement, and warning requirements go into place. So we have a desk guide we put together. If you've not already seen it, I don't know, it's like 25 or 26 pages. And we go through, we provide an overview of the rule, and then we provide a 9-step process for trying to project your program performance under the new rule. All this is based on the new rule. It's in your resources widget. We have hard copies we can send you if you want one. Just email srichter@thompsoncoburn.com. We worked hard to put this thing together. We want you to have it because this is an important rule. The other thing you may know or may not know, last December, we did 2 webinars. It's a whole lot of Aaron, but I think the first one's 2 hours and 40 minutes, where I went through in great detail pretty much every aspect of the rule. And then we did a second webinar, which is sort of the webinar version of the desk guide, where we talk about how to project rates and try to answer a lot of those really technical questions. So those are free. All that's free and just sitting on our website, and we invite you to check it out. This gets it to the second secret word. I feel like there's a theme. Football is the second secret word. Please select the correct secret word from the choices shown down below. So you've got 3 choices. 1 is football, 1 is basketball, and 1 is tennis. highly recommend that you click the football choice so that we can make sure to get you your CLE. And if you do have a team in the big game, then I hope and wish you the best, although I recognize that we probably have listeners who are on different sides of that consideration. So, hopefully at least some of you will be happy, right? Some of you will be happy at least. All right. So the next thing we're going to get into, by the way, while you're still clicking here, is we're going to start talking about, I mentioned there's this new batch of regulations, not the gainful employment rule, but there was a second rule that was published last October 31st. And this second, bucket included financial responsibility, new certification and recertification procedures, administrative capability, and some other considerations. But one of the things the department did, they sort of, you talk about a topic like certification and recertification, there's a lot that can be tucked in there. And one of the things the department did was it added several new requirements to 668.14, 34 CFR 668.14, which is the section of the regulations that govern what goes in your program participation agreement. And for those of you in financial aid offices and elsewhere, you know what that is. This is the contract between you and the U.S. Department of Education that sets out the terms pursuant to which you get to participate in the federal financial aid programs. And the department, there's a regulatory section that sort of says this is all the stuff that has to be in that contract. And it basically, these are the things you have to do if you want to get Title IV funds. And the department, I think, cleverly is the wrong word, but just, decided, I think, appropriately and interestingly in some cases, to include some of these new ideas in that section of the regulation. So these are things that will go into your program participation agreement. And they were part of that rule that came out on October 31st. The first thing I want to highlight is this parent liability concept. And this is not just for for-profits anymore, right? So on March 23rd, 2022, the department put out a policy announcement. You can see the picture on the right here, that in some cases and on an ad hoc basis, it would require corporations or other legal entities that have or could have direct or indirect effects on the institution's administrative capability or financial responsibility to guarantee the regulatory liabilities of the school. So what we mean is, you've got this program participation agreement. It's a contract between the department and the school. And at the very end of it, like most contracts, there's a signature block. And historically, the signature was just by an authorized representative of the school. The problem is the department was having, and is still having, is that when schools, particularly when they close, and they owe liabilities to the department, and the school's gone, and then there are closed school loan discharge liabilities and others that are out there and unpaid, there's nowhere for the department to go. And, in those cases where there is a parent entity, the department would like to ask that parent entity to cover those charges. And some of you are saying, well, for-profit companies have parent entities. That's true. But there are lots of nursing schools with hospitals in the background. There are colleges and universities that have churches and denominations in the background. There are nonprofits out there where there are entities that are up the chain. I haven't heard any discussion about state entities, right? And that would be an interesting concept too. But of course, state institutions are backed as well. The idea, at any rate, is the department is trying to come up with an efficient way to try to recover against someone else. And what they came up with was, we'll just have them guarantee the contract. So instead of just asking an authorized representative of the institution to sign the PPA, in addition, we'll add a signature block and we'll say, hey, we want an authorized representative of the parent entity. And now, just like someone guaranteeing a home loan or a car loan, you have guaranteed this. And we, as a contractual basis, should the school owe a business and owe us money, we can try to recover against the party that guaranteed. Well, it was an ad hoc policy, but in this rule that was just published last fall and takes effect July 1 of this year, there's a new provision that standardizes the requirement that in cases involving proprietary or private nonprofit institutions, the program participation agreement must be signed by an authorized representative of any entity, quote, with direct or indirect ownership of the institution, if that entity has the power to exercise control over the institution. Now, the lawyers in the crowd are saying, but Aaron, I got you, because a private nonprofit cannot have an owner. Well, that's true, but a private nonprofit can have a sole member. And I would not put it past the department to take the position that if a private nonprofit has a sole member, that sole member's control is equivalent to 100% ownership. And, as an aside, I will tell you, I've had someone at the department tell me that before. Now, they don't speak for the department. They're not the law. That was just one staff member's opinion. But I'll just say I think it is probably a commonly held opinion over there. So I think there's going to be a real question here on a go forward basis as to whether and how the department is going to start asking private nonprofit institutions to report parental relationships. And I will also note that the new e-app that has just been created by the department, unlike the prior version, makes it much easier for nonprofits to indicate if they have controlling parents. There is a definition of what it means to exercise control, or at least there are examples. It's an illustrative list, not an exhaustive one. But one of the items is has the power to block significant actions, which again sort of makes you wonder, well, a parent entity or a board of a parent entity would often have the power to block significant actions of an institution of higher education if it's, if it is indeed the sole member of that 501c3 that owns and operates the school. And, on what it means to block a significant action, in the Federal Register, the department, or in the commentary rather, said, well, we generally consider those to be the types of actions described in operating agreements, articles of organization, or bylaws as needing consent by a shareholder or group of shareholders to be approved. I mean, as a practical matter, we do a lot of merger and acquisition work. We've been working a lot with folks who, potentially could be in this position. And we think it's going to be really hard to get comfortable with the notion that a parent entity does not have the ability to block a significant, or rather, I wouldn't want to be arguing over whether the action is significant or not. I'll put it that way. I think the key is going to be whether they really have that power. But TBD, the main point here is just to say, please be aware that the department has formalized in the law a new requirement that parent entities in certain circumstances have to co-sign the PPA and guarantee any regulatory liabilities of the institution. The minimum maximum length rule. I said trademark pending because I don't know if anybody else refers to it this way, but I like it. So I need to try to register it. So for each gainful employment program, so we're just talking about gainful employment programs. This is everything at proprietary institutions. And for the private, nonprofit, and publics on the line, I'm talking about your non-degree Title IV eligible programs, right? There's a new law, and the department says an institution must limit the number of hours in these programs to the greater of the required minimum number of clock hours, credit hours, or the equivalent required for training in the recognized occupation if the state has established such a requirement or is established by any federal agency, or another state's required minimum number of clock hours, credit hours, or the equivalent, if the institution can document that a majority of the students resided in the other state or employed in the other state, or the other state's part of the same metropolitan statistical area. Aaron, what are you talking about? So this is what I mean. So, and I'm talking to the community colleges that offer, say, cosmetology programs, right? If you've got a cosmetology program and the state says the minimum number of hours for cosmetology programs is 1,500, what the U.S. Department of Education is saying is, well, for Title IV, that's the maximum. You cannot offer, if the state has established that the minimum number of clock hours, credit hours, or equivalent for that occupation, for that kind of program that leads to that occupation, where cosmetology is a great example, then you can't exceed that number, right? And the second bit about another state, what the department is saying is, okay, but if you're in Memphis, and, we'll say Tennessee has a 1,500 hour limit or minimum, but let's say Mississippi has a 1,700 hour minimum. I don't know if that's true, by the way. I'm sure someone somewhere is saying, oh, Mississippi is 1,100 there, and get your hours straight. But just for purposes of my example, let's say, again, Tennessee is 1,500, Mississippi, which is right down the street, is 1,700. Then what the department is saying is, okay, then maybe you can do 1,700 if most of your students are actually living, working in Mississippi or something along those lines. But for the most part, what we're saying is the department has created a maximum hours for these programs, and you can't exceed that. Well, the next question most people ask is, okay, but so if we offer 1,700, does that just mean they can only get funding for the first 1,500 hours? No. So look at the second bullet. The department clarifies that students may not receive partial funding for a program that exceeds the maximum length. Again, it's the state's minimum, but the department is taking the state minimum and saying that's our maximum. They don't need to learn a day more because the state has said this is enough, right? And the department in the commentary says, we've determined we don't have the legal authority to partially fund the program. And we don't believe that such an approach is appropriate given the potential harms to students enroll in partially funded programs. Now, I'm sure this is going to spawn a whole industry of, programs with capstone options and things like that. But if you're a private nonprofit or a community college and you've got a GE program or certificate program that is in a licensed profession like this, where the state has created minimum hours, you got to start looking at this. This takes effect July 1 of this year. Keep in mind, there's an exception for occupations where the state entry-level requirement for the job would include the completion of an associate or higher level degree. The department was trying to get at, some folks said, well, what about nursing programs? This is a real problem here. And so the department is saying, well, look, if the state professional licensing entity, right, if entry-level requirements for the job include the completion of an associate or higher level degree, then the program that you offer is exempt from this requirement. Also, where the program is delivered entirely through distance education or correspondence courses, it would be exempt. The department, by the way, did include some language in the Federal Register about implementation, and what it suggested was, they're not going to require you to kick out students who enrolled prior to July 1 and are already in a longer program, but they did say folks who enroll after July 1 of this year have to be enrolled in programs that don't exceed the limit. So this is something, again, if you're a community college offering a cosmetology program, massage therapy, or something like that, any Title IV certificate program, or for proprietary schools, any program, and there are state established minimum clock hour or credit hour equivalent standards, then you need to look and make sure that you're not exceeding those, or otherwise give consideration to what you're doing. Let's talk about, and this is, we got 15 minutes left, and this is a real hornet's nest. I will preface this by saying, we are already, I've had a lot of folks come up to me when I've been out and about saying, hey, when are you going to talk about state authorization, programmatic accreditation, some of these other ideas that are in this rule that takes effect July 1, 2024, and are also being further considered in the ongoing neg reg. Here's what I will tell you. We're going to do a separate webinar dedicated entirely to these topics. And I have begged, and the great Cheryl Dowd at SAN has told me she would be willing to join us for this webinar. If we're really nice, I hear Russ Pullen might also join us. We're going to try to get a roundtable together of experts and really talk through some of this stuff, because we understand that a lot of institutions are struggling with some of these revisions. What revisions are we talking about? So let me just sort of give you a preview. And this is hard to wrap the brain around. But what the department, and again, this is not in the state authorization section of the law, the regs that you may have seen negotiated before. This is in that PPA. It's look down at the bottom in the right-hand corner, 668.14. So what the department is saying now is they've inserted this language, and it's going to be in your PPA. And they say, if an institution wants to participate in the federal financial aid programs, right, as part of that, you agree. For each state in which, and this is the setup, and then there are 3 different requirements, but this setup language is really important. For each state in which the institution is located, students enrolled by the institution in distance education or correspondence courses are located as determined at the time of initial enrollment, or a student who enrolls in a program on or after July 1st, 2024, attests that they intend to seek employment. The institution must determine that the Title IV program, okay, and I'm going to get to this in a second, but I just want to break this down for a second. So what we're saying is, for each state in which you are physically located, you're going to have to make sure that your Title IV programs satisfy the requirements that I'm going to show you on the next slide. For each state in which you have enrolled students in a distance education or correspondence course, and they are located as determined at the time of their initial enrollment, you're going to have to make sure that your program satisfies the requirements. And I want to highlight here, because this is the really sticky wicket. It doesn't say program. It doesn't say students enrolled by the institution in distance education or correspondence programs. It says courses, right? So there is some question as to whether this has to be, when you're talking about establishing what I'm going to show you on the next slide for each program, what if you've got a student that enrolls in the first semester and they've got 2 courses that are online and 2 that are on ground? What if they've got no courses that are on ground in the first semester? So at the time of initial enrollment, you say, well, they're enrolled at home. Let's go back to our Memphis example. And let's say my student lives in Mississippi and is attending school in Tennessee. So what if they are starting their first semester and all of their courses are online? And so at the time of initial enrollment, I say, well, I think they're in Mississippi. Then that means does that mean I have to make sure that my program satisfies the requirements of Mississippi? But even more confusingly, what if their first semester is on campus or their first year and all their courses are in Tennessee, in Memphis? But then the second year, they decide to take 2 courses online in Mississippi, or even what if they decide to take the next 3 years at home and they're located in Mississippi? Like, which state am I dealing with? There's a lot of, as people are getting into programs that are hybrid programs that are online, but with physical clinicals in different places, we're getting calls because this gets very confusing. And I'm not going to try to solve it all here. Again, I'll suggest that you listen into our next webinar. But what I want to highlight for you is, come July 1 of this year, there are these new requirements that your programs have to meet in order for them to be Title IV eligible. And they have to meet these requirements for any state in which your school is physically located, in which you've got enrolled students taking the program online, or finally, if you enroll a student after July 1, 2024, and they say, I plan to work in this state. That's actually supposed to be a concession for schools, because schools during the comment period say, well, wait a minute, I may have a student who's in an online program sitting in Oregon, but they tell me when they enroll, I'm just here right now, but I plan to work in California. Can I if my program satisfies the requirements in California, am I okay? And so the department was actually trying to create a concession here. Okay, I've spent all this time. So what are the requirements? First of all, okay, and let's just simplify the idea. Let's just say, for the moment, keeping it simple, for each state in which your school is physically located, or you've got a student enrolled in your online program, first of all, that program must be programmatically accredited if the state or federal agency requires it. So if you've got a kid enrolled from Oregon, and Oregon requires that for the kind of program they're enrolled in, it has to be programmatically accredited, your program has to have that programmatic accreditation, or you can't enroll that student. It has to satisfy the applicable education requirements for professional licensure or certification in that state. So again, I've got a distance education program. And I'm sitting in Memphis, and I've enrolled a student who's sitting in Oregon, right? I have got to satisfy the professional licensure or certification requirements in Oregon if the program is the kind that leads to professional licensure or certification. And finally, my program has got to comply with all state laws related to closure, including record retention, teach-out plans, agreements, and tuition recovery funds or surety bonds. So if I enroll that one student in Oregon, my program, and this isn't about professional licensure, it's just for any program, I have to be sure that my program satisfies the closure, record retention, teach-out plan, tuition recovery, and surety bond requirements in Oregon, which, of course, some of you are saying, well, wait a minute, doesn't that fly in the face of the whole state reciprocity agreement concept? Arguably, and there were many people who raised that concern during negotiated rulemaking, but the department felt like, with school closures on the uptick and things along those lines being concerns, that this was important enough to move into that space. So, and I just want to be really clear. Under the prior framework, schools, you could still enroll a student in Oregon under current law if you made no determination regarding Oregon. You could just put on your website, we've made no determination regarding whether Oregon satisfies these requirements. And you tell the student, we've made no determination. You could still enroll them, and it's sort of on them. Come July 1, what the department is saying is you have to make a determination. And if you do not satisfy those requirements, you can't enroll that student. Big sea change. And the commentary, the department makes very clear that it added this requirement, 668.14b32, Roman numeral 1 and 2, to require all programs that prepare students for occupations requiring programmatic accreditation or site licensure to meet those requirements. There's no question that that's the intent of this rule. It also observes that if programmatic or licensure requirements exist, an institution must follow them with respect to the students attending from those states. That also means that if an institution cannot determine that its program meets the education requirements for licensure or certification, it cannot offer the program for future students in that state. And a lot of people said, well, wait a minute, you know how hard it is to get professional licensure and certifying organizations on the phone? I mean, what if they're not responsive? What if we can't get them on the horn? And the department is saying, sorry, but if you can't make the determination, you can't enroll the student. So what I expect, among other things, I expect 2 or 3 things to happen. I mean, 1, I think folks are going to push back on the department. 2, I think many institutions are going to say, well, we only have 2 students in Oregon right now, and I'm a Memphis-based school, and it's just not worth it, right? I've got 1,000 school kids in California. I've got 1,000 kids in Florida. and I've got 3 in Oregon. And what I fear is going to happen is that in states that don't have as large as student populations, or that are harder to get to, or where it's difficult to contact student licensing and professional boards, if the return on investment is not there for schools, they're just going to drop out of those states. And that could be just because the state is a smaller state and doesn't have funding, and that's going to, to put enough people on its licensure board or whatever to pick up the phone, and that could have an impact on access. This is just Aaron obviously talking about, what I fear, but I think there's a real legitimate concern out there. I've had lots of conversations. Certainly this is not a unique concern, and it was expressed by many in the comments to the public rule. So we'll see what happens here. I think there will continue to be a lot of discussion and pushback on the department around this. But please be aware that this is out there and it takes effect July 1st. The department also makes clear that these new requirements only apply to the states where institutions are enrolling students and where they're either living at the time of initial enrollment or where they attest that they wish to live. Let's be real clear. We're not talking about residency. We're talking about location, right? And that's consistent with the changes that were made by the Trump administration. Also, the department acknowledges if an institution is not enrolling students from a given state, you're not obligated to determine anything. So you don't have to make a determination with regard to every state. But for any state for which you have not made a determination, to quote the department, it just cannot offer the program to anyone in that state. There are these related professional licensure disclosures that sit in 66843, which is the consumer information part of the federal regulations. And this was the traditional 3 lists that folks have had, last 3-4 years, that schools have had to create. And, you had all the states and you said, yes, determination, no determination. We've not made a determination. So we're replacing that now with basically a 2-list concept instead, because you can't have we've not made a determination list, right? I mean, you've got a list of all states where you've made a determination that the program does and does not meet such requirements. And if you haven't made a determination, you don't have to put anything on the list necessarily, but it also means you can't enroll any students from that state. By the way, I should just say there's nothing preventing you from continuing to have 3 lists, but under the new framework, as far as Title IV students are concerned, it's either yes or no, right? If an institution is not enrolling students from a given state, again, I'm just requoting that language, it's not obligated to determine anything, so you don't have to make a determination for every single state. You just can't have Title IV students enrolled in the states where you've not made a determination or where your determination is no. There's also sort of a continuing obligation on the part of the department, or they continue to obligate institutions to provide certain notifications to students, including in the case where a program's curriculum does not meet state education requirements, or if the institution has not made a determination. I've had a conversation with many in the industry, and I think many of us agree that this is very confusing. I mean, the new rule says if you've not made a determination, or you've determined that you don't meet state requirements, you can't offer the program to Title IV students from that state. But then there's this requirement that says you have to provide notice to this effect that you've made these determinations or you've not made a determination prior to a student's enrollment. I think that just seems you're not going to enroll the student if you've made that determination. So it's a little confusing. If folks raised that during the comment period, the department seemed to say, well, we still think the disclosures are worthwhile. But I just want to be really clear. I think what's confusing is if I read this language and the department is telling me that I have to provide a prospective student with notice that my program does not meet state requirements before I enroll the student, that seems to imply that I can enroll the student. And I just want to be very clear that the new law prohibits that. Under the new law, if your program doesn't meet the requirements in which the student is located, you can't enroll them. Or if you've not made a determination, you can't enroll them. So I guess you would just be disclosing it to a prospective student so that they know that fact. And don't continue to spend time evaluating your program, basically, but you cannot enroll them. Similarly, if you determine that a program's curriculum doesn't meet the state education requirements for licensure, for a student who's currently enrolled, you have to notify them within 14 calendar days. I think that may have to do more with when this law becomes effective, making sure that you are reaching out to students. By the way, there is also an open question as to how this is going to be implemented. Maybe it's there. I looked last night for about 2 hours and I could not find in the commentary where the department talked about sort of its thinking on how to transition students in. Again, it could be there, but I expect that we'll get more guidance from the department on all of these topics, including state authorization and these professional licensure disclosures in the way of a dear colleague or a QA document or something that will give more instruction on how they want institutions to manage sort of the transition, because you may have students, halfway through a bachelor's degree program and they're in a state where you don't meet the requirements and they enrolled understanding that and they signed some disclosure. So the question is, well, what do you do with that student? Finally, we're just about at time, but this worked out pretty well for a change. Financial responsibility reporting. So another thing that's in this new rule that takes effect July 1, I mentioned earlier, the Trump administration did not get rid of this framework. It was introduced by the Obama administration. And this is the one where, if there are certain events that occur between your audits that the department thinks are potentially material to your financial responsibility, you are obligated to report those events to the department within a certain time frame. And if the department subsequently determines that they are material, it could require some sort of letter of credit or other financial protection. The framework fundamentally works the same way here. You've got two buckets. You've got mandatory triggering events. So except for the mandatory triggers that require a recalculation of the institution's composite score, a mandatory triggering event constitutes an automatic failure. So within the mandatory triggering event bucket, there are actually two little buckets. One is for mandatory triggering events that require no recalculation of the composite score. If they occur, you are deemed to lack financial responsibility, full stop. Now, there is some opportunity to try to demonstrate to the department that there's still no material adverse effect on the institution and its financial wherewithal, but the way the law reads, you're automatically no longer financially responsible. The mandatory triggering events in the other little bucket are those that prompt a recalculation of the composite score. So if you have litigation that results in a judgment, and so you've got a real number, and you report that number to the department, and the number is, it has to be reported, but it's a small number, and they recalculate your composite score, and it's 2.7, then it's not material. That's how they're determining materiality for that sort of subcategory of mandatory triggering events. The financial protection required in the event that the department concludes that you've had one of these mandatory events and it is material is no less than 10% of your total Title IV. What do I mean by that? So, the department would look at your prior year audited financial statements and how much net Title IV you took in. And by net, by the way, I just want to be real clear, I mean net what you sent back to the department in the way of R2T4, not net credit balances that you issued to students. Sometimes people confuse that. So anything you take in, it counts in this number, including if it gets issued to a student. The only thing that gets netted out is dollars you actually sent back to the feds. So they would look at that number, and if you had $10 million in federal financial aid in the prior award year, then they would require you to post a letter of credit equal to $1 million, 10% of the 10, right? And they can increase that percentage, but that tends to be how the department manages risk and determines the amount of the sureties that it requires. There are also these discretionary triggering events, and the idea is that these may not represent any kind of significant adverse effect to the institution, and there's some further determination. But if they occur, you still have to report them to the department, and there is still some consideration, and you may have to demonstrate that they're not significant. If they are significant, or if you have multiple discretionary triggering events in a 12-month period, again, you can end up having to post some sort of financial surety. And, safe to say that the primary effort by this administration, which is very consumer protection oriented, was to expand the range of mandatory and discretionary triggering events. So I'm not going to go through all of them. We don't have time, and that's a whole nother presentation, but we are finalizing. So we did a financial responsibility, or however you want to think of this rule, guide coming out of the last rule. And it actually still is the law of the land. We're preparing an updated version of this guide that we're going to release closer to the July 1 effective date of this rule. So keep an eye out for that. And it's just 2 or 3 pages, and it just has a big chart and shows you, here's the event. If it occurs, here's the timeline for reporting, et cetera, and has some other information about how to report. So that'll be on our website. And the QR code you see here is to our higher education resources page. And that page has all the stuff we produce. So all the gainful employment stuff, the white papers, the webinars, everything. You can just scan that QR code and go right to that website. You'll also have the recorded version of this presentation. And then lastly, but very quickly, I just want to hit on 2 sub-regulatory items. The first is the third-party servicer guidance that rocked the world last March. I don't think in my career there's ever been something that came out from the department at the sub-regulatory level that got so much attention and discussion. The department dialed it back in April of last year, following a lot of feedback, announced that it was going to delay the implementation of that guidance and provided some important policy clarifications. And you can go look at that updated information if you click on the link here. I just wanted to highlight, there's a lot of discussion out there about whether the department's going to try to do this before the presidential election or the end of this term. I mean, my sense is that it is something they want to get to, but I think they're also being pretty cautious. They've also got some really big other fish to fry with all these other rules in play. So, hard to say what they're going to do. My instinct is that they're still going to try to get it done. That's kind of been their MO throughout this whole administration. Let's get it across the line. But I don't know for sure. And what is interesting is the unified agenda still suggests that the department intends to create a new rule on this topic, and it's targeting October of this year for the release of the proposed rule. And it was always kind of odd that the department was rewriting this really significant sub-guidance and it's simultaneously indicating that it was going to start a negotiated rulemaking process. So right now, all of this is to say, hard to know what's coming. We think we're going to get new guidance. There's some suggestion there will be a new rule, but really not clear. The last thing I just want to reference is the incentive comp redo. Some of you may remember on the same day that the department released that third-party servicer guidance last year, they also asked for feedback on incentive comp and specifically on the bundled services carve-out that exists in the incentive comp guidance from 2011. That is really important, particularly to the online program manager industry. And I'll say both the third-party servicer guidance and the incentive comp guidance and request for feedback, they came out on the same day for a reason, because the through thread for these two topics is outreach and potential regulation of online program managers and other bundled services providers. Like that's clear. The OPMs are clearly the target here. That's that, and the department was upfront about that. I'm not speculating. So, I think this is still a priority for this administration, and I would certainly expect that we may see something on both of these topics. Although the incentive comp topic in particular, I think, is very delicate, and there's a lawsuit out there right now. Some of you may be aware of to you that may have some impact on some of these considerations as well. So it'll be interesting to see how this plays out. But these are both important topics for you to be aware of. All right, here's your third secret word. It is jersey, not cardigan or sweater, but jersey. So please take a few minutes to click through and select the appropriate secret word. Again, it is jersey. And then while you're doing that, I'll just go ahead and speak. The last few slides here, I'm going to just click through them rapidly, and I'll tell you what they are while you're picking your secret word. The first is just the slide with our resources page on it and the QR code again. And then, just a reminder that we've got our blog that you can sign up for if you want to get our blog materials, which include announcements of our webinars. And then we've got our page on YouTube, on our firm's YouTube site that has there's a higher education playlist that has, I think we have 71 webinars there now for you. And then we have various compliance materials. And then lastly, I'm going to end here and show the disclaimer, because I'm not your attorney and this is not legal advice, unless I am your attorney. So I'll tell you what, I'm just going to leave this up so you can continue to look at the secret word and select it. And then while folks are doing that, I'm actually going to switch over, and 3:38, I think I have about 10 minutes here before they boot me out of the system. I'm going to try to look at some of these questions. All right, so let's go. I'll just sort of scooch through. Let's see. One person asked about the Chevron, the Supreme Court litigation that's sort of contemplating the lines around Chevron. The question is, how do I think the court's going to rule? I'm not going to hazard a guess on how I think the court's going to rule, but I will say this. So for folks who may not be aware, the Supreme Court has been considering cases. EPA West Virginia is a great example from a couple years back, and now they've got a couple more in front of them, where they are reconsidering the amount of discretion to give to agencies. And what we've got right now, because we're not getting a lot out of Congress over the last 10 years, what we've seen is the executive agencies becoming more active. both the White House out of executive orders, and then also, the U.S. Department of Ed and others with a significant increase in rulemaking, because they're trying to fill the gap, right? I mean, how do you move that policy agenda forward if Congress isn't making any plays? So the way that they're doing it is through rulemaking and regulation, executive orders, and others. And that has resulted in an increase in the number of lawsuits, in some cases by AGs or by industry participants, who are saying this is overreach. Regulatory agencies can only do what they're authorized to do by statute. I mean, their job is to execute the statutes, not to invent new laws that are beyond the purview of congressional authority. And so they're being challenged more regularly. And so the question is always that courts face is, well, how much discretion do we give those agencies? Like, how much discretion do they have to sort of say, Congress said this, and so we're going to build this whole thing out of that? And it used to be coming out of the 90s, and there was this big case, Chevron, and its sort of descendant cases that said, well, we're going to give agencies a lot of discretion. And the Supreme Court is moving that line away from agencies. And what's interesting is that means like this financial value transparency and gainful employment rule. This is the third time the department's been sued. Every time they've been sued over this rule. They lost the first time on I'll say sort of technical grounds around the thresholds they used for repayment rates that were part of that rule. The second time they had lost or were losing, I'll say they were losing. There was already a grant of motion for summary judgment, but then the rule got stripped off the books. And they're being sued again. And this is probably the most problematic version of this rule. But what's interesting is, if the Supreme Court is moving the agency discretion line away from agencies and towards the regulated industry, what that means is decisions from 10 years ago that the department had a certain amount of authority to do certain things might break differently. And, that's a great example where that rule was already sort of troubled. But one of the things the court never really seemed to question in the prior versions of that litigation was whether or not the department had the authority to create the rule in the first place. Now that question is back up for debate. And that the Supreme Court cases break in a certain direction, it could lead a court to decide that this whole idea is beyond the scope of the department's authority. So these are really impactful cases for administrative law and regulation. There's no doubt about it. It's a great question. Let's see. Let's see. Somebody said they were having trouble getting to the BDR claim characteristics website. I'll double check. The links in the PDF should be active. But if for some reason the PDF was converted in a way off the slides that we lost the links, then we will go back and we'll redo it and we'll distribute that PDF to everybody who registered for today's webinar, because I want to be absolutely sure that you can get to all those links. But that should be an active link. So I'll double check. And if for some reason it's not, we will reissue that PDF to make sure everybody can get to the links that are in the webinar. Let's see. Do we anticipate BDR claims will continue to be dropped to institutions in large batches? Yeah, I think so, particularly in the near future. I think the department has entered that phase for claim bunches that were received between June and November of 2022. I think they are now moving into the issuing batches to schools that received large number of claims during that period. Let's see. Is an institution now required to ask an applicant where they intend to seek employment? So this may get to those professional licensure questions. I haven't thought about this in this way, but I don't think that the department is requiring you to ask that question. I think the department was trying to create an opportunity for schools to ask that question. So I don't think you're obligated. You have to make a determination regarding where a student is located. That is in the law, right? But I don't think you have to ask them where they intend to be employed. I think you can. And if you do, and they're willing to attest to that at the time of enrollment, and it's in a state where you are, meet the state's requirements for the program, then I think the department's saying, okay, then you can enroll the student. If you read the commentary in the Federal Register around this issue, it is, I think, clear that the department meant that additional language in the professional licensure section to create opportunity for schools, not to create an additional burden for them. Okay, I'm just going to click down to the bottom here to the disclaimer. There we go. And then let's look at some more questions. Okay, what happens if the school has an agreement with Sarah for distance education programs? And we are talking about determine. Yeah, so again, I think this is the question is about determining whether or not your program satisfies professional licensure requirements, meeting those three requirements. Does it satisfy requirements relating to closure, et cetera? What the department is saying is that your program has to satisfy these requirements without regard to whether or not you are in SARA, right? So let me say that again. I mean, obviously, if we're talking about the state requirements in the states where you are physically located, that's different because SARA doesn't dictate that, right? Because you're physically located in those states. So what we're talking about here is, to the extent you are enrolling students in online programs and you're a SARA participating institution, how might that impact your requirement under these new laws to ensure that the program satisfies professional licensure and certification requirements in that state where the student is located, or the closure, teach out, and surety bond type requirements in the state in which the student is located? And I want to be really clear. The answer is your participation in SARA does not impact that obligation. That's the department's point, is you may be authorized to offer that online program to that student in Oregon, notwithstanding the fact that your institution is located in Memphis. But even if you're in SARA, you still, if you're going to enroll that student, have to ensure that your program satisfies, if it's a program leading to professional licensure and certification, the Oregon state requirements and any requirements the state of Oregon may have relating to closure, teach out, surety bonds, et cetera. And that's, I mean, I'm sensing from the questioner, folks are saying, well, wait a minute, the whole point I'm in SARA is so that I don't have to satisfy the state requirements in Oregon. That's the point. Yes, agreed. And many people were concerned about this. The folks out at SAN and WCT and other places in the U.S. that deal with this and raised this concern and said, hey, the point of the reciprocity agreement is that you don't have to satisfy state requirements if they're part of state authorization. Now, if they're outside of state authorization, you still have to satisfy those requirements or you're still subjected to them. So, if there's just a good old fashioned consumer protection statute in Oregon that says any citizen of ours that satisfies a contract, if you, commit fraud, then they have an action. I mean, you're still subject to that, right? Because you're doing business with someone in Oregon. But any laws relating to state authorization of institutions of higher education, if you're in SARA, the idea is you're not supposed to have to satisfy them. And what the department is saying is, we hear you, but if it's Title IV, then your program still needs to satisfy the closure, teach out, and other requirements. So it's sort of eroding a little bit the whole state authorization concept. And the department and the consumer advocates and others, their argument is, look, these closure related provisions and things are really important, and notwithstanding state authorization, you need to comply with those. But it's challenging, and it's and then you have this question of like, well, what do you mean by closure requirements? Like state tuition recovery fund, refund requirement. I mean, what exactly is incorporated in that? I think there's going to be a lot for schools to figure out for certain. And again, we plan to do another webinar on this topic and to delve into some of these issues with greater specificity to the extent that we can. If we're able to get an attestation from a student that they intend to seek employment elsewhere, and the student is located in a state where we don't meet state requirements for licensure, can we then enroll them and get Title IV? Yes, if the student is attesting that they plan to work in a state where you do meet the state requirements. Does that make sense? So if your program meets state requirements in California, and the student's physically located in Oregon while they're taking the program, but they sign an attestation saying, look, I'm from California originally, my parents are down there, I plan to go back there and work, I'm just in Oregon right now temporarily, then you can say, I've got the attestation, hey department, my program does satisfy the applicable requirements for the state that matters here, which is where this student intends to go work, but you have to have the attestation. All right, just a couple more questions. Let's see. Here's an interesting one. Is this state certification requirement just for those students getting federal financial aid or any student? I mean, I read it as the way it works, it's a program level requirement. And what it says is that you have to satisfy the requirement for each Title IV program for each state in which you are physically located or you enroll a student. And I'm going back, let me push back to that language. Here we go. By the institution in distance education or correspondence courses. So I don't know. You know what? This isn't much of a paraphrase, but I would want to look really closely at the language. But I really see this as a Title IV eligible program requirement and not a student-based requirement. But it's a great question, and I don't know the answer to it off the top of my head. You know what, though? I'm going to take these questions that you guys are asking and I'll put them into the queue, and we'll make sure we're thinking about them when we prepare this other webinar that's specific to this topic. We have a lot of questions on this topic. I know it's creating a lot of consternation for institutions right now. Let's see. I'm just bouncing around. Let me see if I can find one more. Yeah, so I have one question. Someone representing a divinity school. It says, odd as it may seem, people who earn a master's of divinity generally do not enter into high-paying jobs. I believe it. I see the note that programs in theology are of particular concern, right? Or a high percentage of them seems like they may not satisfy these metrics. Can you talk more about the metrics used? So let me say a couple of things. The first is many people raise this concern, as you would expect in the comment period to this rule. I mean, there are a lot of problems with this rule, but many people said, look, we've got all these programs that, aren't designed. People don't enroll in these programs to make money. That's not their primary concern. That's not the best way or even a meaningful way to measure the value of these programs, et cetera. I think those issues have been raised. ACE, the American Council on Education, raised those issues way back in early 2023 when the department first started talking about financial value for programs. CCCU raised those issues, including in its, by the way, the Council of Christian Colleges and Universities filed comments in response to this rule and raised many of these issues as you would expect. And the department sort of said, we hear you, but we're not persuaded, right? The metrics are a debt to earnings rate and an earnings premium. And so philosophically, the idea is they're going to look at what you're charging students or the amount of debt they're taking on for a group of students, and then they're going to compare it to the earnings those students make. And if the resulting ratio, actual earnings those students make, by the way, and report to the IRS, and if the resulting ratio doesn't exceed a certain threshold, for a graduate theology program, you would not lose Title IV eligibility, but you would have to start sending those students to the department's website where it's going to say this is a low financial value program or a high debt burden program. Your divinity students may not care, actually. And to some respect, they may say, well, of course, I know that, but it's not great for certain. The other metric is an earnings premium metric. And the idea there is to say, well, if we look at how much your folks are earning, are they making more than people who have no college education? For longer programs, master's programs, I would think that would be less of an issue. I won't say never an issue, but less of an issue. If you want an exhaustive discussion of these ideas, again, please, I welcome you to check out the desk guide and the 2 webinars we did in December, because we talk about these things at great length. All right, folks, thank you so much for tuning in. Hope everybody learned something. We always appreciate your time, and please keep a lookout for more content that's coming your way. Like I said, we're always working to think of what will be useful for the community and putting together new webinars and white papers and such to try to get out there to help, and particularly right now, because we understand there's just so much coming down the proverbial pike. Other than that, I'll just say, have a great day, have a great week, and be safe, and we'll see you next time.